Zoom. Thanks for joining us. It is a rainy, dreary day in Pittsburgh. Hopefully it's not as dreary as you are. My name is Jess Bayless. I am the Library Services Supervisor for Civic CLP and a program partner for the series. We do programs like this with PMC. We have speaker events. We provide resources on voting. So we will provide the slide deck at the end, an email to everybody. Please visit our website. I also want to.
That's the reason I keep.
They are a wealth of information. Lori could not be here today, but please also visit their website. Their information is included on the following slide here. They are located downtown, and while we can't offer legal advice, we can do everything but. So shout out to program partners. And then last but not least, I'm going to turn it over to my colleague Ann Lee to just give you a little bit more information.
Thanks, Jess. And just very quickly, I want to give a shout out to our library supporters out there in our audience this evening. We included tonight's program in our Planning Well at the Library series, and this series is designed to help people meet their personal and philanthropic goals. So we hope that you enjoy how to administer an estate this evening, and thank you again for all of the ways you guys choose to support the library.
Hi, my name is Mark Tamburri. I'm one of the board members for PMC. It's Pennsylvanians for Modern Courts. I also work for UPMC, so I always have to be careful when I'm talking about PMC. But I'm a lawyer for UPMC, but I'm also on the board of PMC. And just to tell you briefly a little bit about PMC is we're nonpartisan, we're not for profit. And basically, we're trying to make sure that everyone's got impartial access to courts and in front of impartial qualified judges. But part of the mission of PMC is to promote programs like this, to provide access to people who have a better understanding about the courts and resources available to you. PMC has a long history. It goes back a long period of time. Former Governor Casey there. But the goal was to reinstill some confidence in the judiciary. And really what we want to do is promote access to the courts and promote people's understanding of the courts. And this is just a part of many series that we offer. Sorry, Jess.
No, it's okay. This is how I get my steps in. Go ahead.
Okay. So before I turn it over to Carol here, I just want to make sure everyone's aware of some other programs we have coming up, and hopefully you can see that. I've attended a couple of these programs, and they are really excellent resources to the community. Okay, this is where I stop having any understanding of what I'm talking about. So let me turn it over to Carol Gross, who is a trust and estates lawyer, and will take it over from here. But we're really glad that Carol agreed to provide this program and be a resource to all of you. So I hope you have lots of questions and are ready to hear Carol's expertise.
Thank you. Can we go back one slide?
Oh, sure. Yeah.
Oh, it skips. Okay. I don't know where. Oh, got it. Okay. Hi, I'm Carol Sikov Gross. I'm back again. So I lived for another week, so I don't have to worry about opening my estate at this point. At least my kids don't. So that's a good thing. Okay. All right. So people have this question all the time, am I going to need to open an estate if I have a family member or a loved one or a good friend, somebody who passes away? And so the first question is, when the person passed away, did they have assets in their own name alone that don't have a named beneficiary or don't have a joint owner? Because remember, when we talked about estate planning last week, I told you that assets that are titled with named beneficiaries passed to those beneficiaries by operation of law, and assets that have a named joint owner passed to the surviving joint owner. So this is the question, and sometimes you just don't know, but you want to try to find out. And assets consist of things such as real property, a house, campground, something like that. Personal property, bank accounts, all right, and their personal items, you know, all that stuff that's in your house, you know, your crystal, your chairs, your televisions. So certain assets, if they are in your name alone, the only way they can be passed and transferred to another person is if we open an estate. And that's where you see this lovely word probate. So people say all the time, well, Carol, what is probate? And do I want to do it? Don't I want to do it? What is it? All probate is filing a will of record. So basically, God forbid somebody you knew had died about, so say 7 to 10 days ago, because that's about how long it now takes to get a death certificate. We could see about opening up their estate. We would walk into the local
Recording in progress.
county. It is still called the Register of Wills Office because we little, oh, okay, this one's next. All right. So the Register of Wills, ROW, that's what they, okay, that's the clerk of the orphans court, and they open up estates. And I said they're an elected official except in Allegheny County. We're special. Okay, and that's where you go to open your estate. All right, forward your head. We're not. No.
Sorry.
I know, sorry about that.
No, it's okay. Just have to click into the screen.
Forward.
Are you, do you want me to redo it, take control or something?
No, don't want
Okay.
to. We're looking for a little flow chart here. Okay, so this is a little flow chart to kind of give you an idea of when you need to open an estate. So the first question is, did the decedent own any property? If the answer is no, you don't need to open an estate. If the answer is yes, you then go over to the next box. Was all of the property titled jointly? If the answer is yes, you don't need to open an estate. If the answer is no, did all the property have beneficiaries? If the answer is yes, again, you don't need to open an estate. And if the answer is no, then you might have to open an estate. Okay. Question, yes.
Yeah, this is for my own information because my kids don't think I'm ever going to die on them, so they won't want any parts of this. So I figure I'm going to try to get this done. Now, my husband died like 30 years ago. I don't think we ever changed the names on the property. I think it's in both our names yet.
That's okay.
So what do we have to do? Is there something I have to do to take his name off?
No, if you, okay, so a house, if it's jointly titled between a husband and wife,
Right.
or between other people as joint tenants with right of survivorship, on the death of the first person or spouse, you don't have to do anything.
All right.
You just need to put a death certificate with the deed so that when they would go to sell it or transfer it later, they would have the death certificate for your husband there.
Okay, the person that did my paperwork, the will, all right. I don't think he's alive anymore. I don't know if he did anything. How can I find that before I die, what I should look for?
Okay, so as I told you last week, you should, if you have an existing will, you want to know where that original is.
I have that.
Okay, and that's all that's going to be needed along with the death certificate, all right, to open an estate, as well as some other paperwork, which we're going to get to. Okay, but we'll proceed for a minute. All right, so the question is, do we need a lawyer to open an estate? And that's not required, but if you go into the Register of Wills office here in Allegheny County, they will strongly suggest that you get an attorney. And the reason that you want an attorney is somebody to do the paperwork, to do it correctly, because there are certain timeframes that are involved. All right. It's just a very helpful thing. And sometimes neighborhood legal services may be able to provide some free assistance. And so basically it says it can prevent problems. I will tell you that sometimes people try to administer estates on their own, and sometimes it's okay. But sometimes it's helpful to have an attorney, somebody you can talk to make sure that you're doing things correctly so that you don't get into trouble with the Pennsylvania Department of Revenue. Okay? Because that can be the issue. And then the executor under a will, or the administrator, if a person dies without a will, can be held personally liable if they don't do things appropriately. And so that's why you want to have some advice to help you. Okay, so basically we're not providing legal services here, and I am not your lawyer. I'm not giving you legal advice, I'm just giving you information, okay? So a lot of times you'll hear people want to avoid probate. Why? Because they've heard, they went to a free lunch, they got a free dinner, they went to a seminar where they said probate is some horrible, awful thing and you don't want to do it. If you live in Florida, California, New York, Arizona, some of those states, probate is a horrible and awful thing. In Pennsylvania, if somebody came into my office, not right now, but if they came into my office tomorrow morning and they had a death certificate, an original death certificate, an original will, we would put together papers to open the estate, and normally in about an hour and a half to 2 hours, you could get an estate open. Okay, so it's not bad. It doesn't take months and months like it could in one of those other states that I mentioned. Not that they aren't lovely for weather, but they're not great places to open estates. Pennsylvania is much simpler. We do that wonderfully. Okay. All right. So these are some of the problem areas that people can run into if they don't have any advice and they're trying to do this without some help. There's issues with payment of bills, because when you have an estate that may not have enough money to pay all of the bills, there's a priority as to how things get paid. And if you pay bills out of order, and so the higher priority creditors don't get their money and the lower priority creditors get paid, you could have a problem if you're the executor or administrator of that estate. If the person was on Medicaid when they died and you didn't get a claim from Medicaid and didn't take care of that, you'd get into trouble. If you didn't pay the inheritance taxes or the income taxes that were necessary. So, and you didn't distribute the assets to the beneficiaries correctly. Because maybe you're like, well, I like this person better as an heir, so I'm going to give them some more. Well, their share was only 50% and you gave them 55%, you could have a problem. All right, so again, these are the types of estates, and we talked a little bit about this. Testate is the person died with a will. That's called your testamentary document. And the executor of the will is the person who would be in charge of the estate, and that is the person who would get sworn in to handle all of the details of the administration. If the person died without a will, they died intestate, and that's where the state law would control who gets their property and who would be the administrator of the estate. Okay, in your will, you get to name an executor. All right. So again, we have beneficiary designated assets, jointly titled property, not controlled by the will. We have our probate estate, which might have specific gifts. I leave $1,000 to the Allegheny County Law Library and the Carnegie Library and PMC, and not to you PMC, but the PMC, okay? And then the residuary, whatever's left, is going to go to my residuary beneficiaries, okay? All right, now, so these are some basics about probate. The executor is named in the will, the administrator is under state law, next of kin, a spouse, adult children, parents, okay? To get a person sworn in, we take the original will, we take the original death certificate, we take what's called a petition for probate and grant of letters. And I believe we'll have a copy, a picture of something in about 2 more slides. And those papers walk over to the Register of Wills office on the 1st floor of the City County building after going through a metal detector. And you can get sworn in, and you raise your right hand if you're the executor, and you say, I will solemnly discharge the duties of my office in accordance with the laws of the Commonwealth of Pennsylvania. And you have to pay a fee for doing that. The Register of Wills office will not accept personal checks. Just so you know, they will accept cash, and I believe credit cards, but they will not take personal checks. In some counties in the Commonwealth, you can get sworn in now online because of COVID. They now allow it's like a Zoom swearing in session, as opposed to in the past, you always had to go to the Register of Wills office in person with your paperwork and yourself to get sworn in. They've started that in Allegheny County fairly recently. I haven't done it yet because my office is right next to the city county building where the Register of Wills is. So I think it's kind of silly for me to Zoom when I can walk across the street. But it is possible now. And then I'm not sure how you get the papers to them ahead of time. I think you may have to mail things in, and you can get sworn in on Zoom. All right. And when do you do this? Well, clearly not until the person passes away. And then you do want to try to open the estate quickly. Why is that? It's because it's much easier than to handle the person's assets, close out their bank accounts, deal with their bills if you do it quickly. All right. There's no requirement that you have to do it within so many days, but normally within a few weeks, you'd like to get it open. Sometimes it can take months, but in the meantime, nobody can do anything with the house, for example. Nobody can deal with the bank accounts. It gets to be a problem. All right, so again, this first step is you want to find the original will. So you know where it is, but not everybody does. Sometimes that's something you have to search for. Sometimes the original will can be in a safe deposit box. Now, you could go to the bank if you have the safe deposit box key, tell the people at the bank, I have a copy of the will which shows I'm the named executor. I need the original will. I believe it's in the safe deposit box. Here's the key. Now, they won't let you look in the box, but they will go and open the box and do what's called a will search, bring you the will back if it's there, and then you can use that to get sworn in. All right, and we'll hope that you already have the death certificate. There's an estate information sheet. We don't use that so much in Allegheny County. In some counties they do. And then you go to the registrar's office. You want to have an ID. If you're with an attorney, you probably wouldn't need one because they would say the attorney knows who you are, so we're satisfied with that. And they want, you show them these papers and then you get sworn in. And then you get what's called a short certificate. Now, a short certificate used to actually be a short piece of paper. Okay, now everything's printed on computers, so it's a regular size piece of paper, but it's kind of a manila thing, a special grade of paper. And that's proof that you are appointed as the executor or the administrator of the estate. If you're an executor, it's letters testamentary. If you're an administrator, it's letters of administration. And then you pay this fee. And right now for an estate of $100,000, I think the fee would be a little over $300 to open the estate. Okay, so this is the estate information sheet. It has information about the executor, the administrator, and some other information. And these are all online forms that you can get. And all these places are the same. It's the Orphans Court forms on the Unified Judicial System of Pennsylvania. So this will appear in the slides that you have when you get them after the presentation. This is our petition for probate. It's a two-sided form. There's a place for information about the decedent, information about the executor, if we're having a will, the date of the will, if you have some idea about the assets in the estate, like we know there was a house at 123 Main Street. And this gets filled in. It is signed and attested to by the executor. If you're doing letters of administration, you have to list the heirs because they want to make sure that they're granting the letters of administration to the most appropriate party. So that if you're a grandchild, but there's a living spouse and a living child, you can't get the letters first. They would have the right to do that because they're closer relationship. Okay. All right, so we have our short certificate, and that then gives you access to be able to collect the decedent's assets. So that would be, for example, going to the bank and saying, I'm going to close out the decedent's account, put the money into a new estate account. Because think of an estate as if you're setting up a small business. And so it will get its own tax identification number. You can no longer use the decedent's social security number after they pass away. You want to collect information about the decedent's debts. Who do they owe money to? If there's a house, usually you're going to be finding utility bills, but maybe they have a lot of medical bills from you, PMC, there, I threw you in, okay. And they owe some co-payments or something like that, all right? Usually we'll want to open an estate checking account because your business is going to need a way to pay its bills. And you as the executor or administrator are not supposed to commingle those funds and put them in your own bank account. That would be a no-no, okay? And eventually, once we go through more steps, you will eventually distribute money to the beneficiaries or the heirs at law, but you can't do that first because creditors have priority. The Pennsylvania Department of Revenue has priority to collect their inheritance taxes. So inheritance taxes, I'll just remind you, to spouses, the tax rate is 0. To children, the tax rate is 4.5%, unless the children are under 21, and now they don't have to pay any inheritance taxes. That's a recent development in the law in the last couple of years. Siblings, 12% inheritance tax, and everybody else is 15%. If you leave money to charity, like the library or PMC, they don't have to pay any inheritance taxes. Those are deductions and can help save taxes. Okay, so this, yes?
Would this account, like those tax numbers you just gave, would that be true for assets not in Pennsylvania, like real estate elsewhere?
Okay, so if you had real estate in another state, you would not have to pay Pennsylvania inheritance taxes on that property because it's not in Pennsylvania. If it's Pennsylvania real estate and you own it, but you die as a resident of Ohio, there will still be Pennsylvania inheritance taxes.
So, but you would have to probate in that other state?
You'd open your estate in Ohio, and then you would have what's called ancillary or secondary probate in Pennsylvania to deal with that piece of real estate.
Just with that, for that one thing?
Yes.
So it's like 2 probates?
It's like 2 probates if you have property in 2 different states. Yes, so that's where having an attorney help you do an appropriate estate plan would help stop that from occurring. Okay, all right.
Where do you get a certificate of death?
Where do you get a death certificate? Well, normally you get a death certificate from the funeral home. Okay, they would do that. Sometimes you get them from the coroner's office if they've declared the person deceased and they've issued the death certificate. If the person died several years ago, you would get it from the Vital Records Department, and you have to pay for these things. They're not free. Okay, but you can do that, but you have to have, I couldn't just like get some strange person's death certificate. I'd have to have a reason for that. All right, so when we're doing estate administration, we're getting the executor or administrator sworn in. We're providing notice to the beneficiaries. And the state put this in law several years ago. Why? Because some people said, I don't like my siblings who are also heirs of this estate, so I'm not going to tell them that mom died and not give them notice. But now that's the job of the executor or administrator. Within 60 days after death, they're to give notice. You're supposed to advertise in the state. Yes, sir.
So the beneficiaries and the heirs are all named in the will?
The beneficiaries would be named in the will if there was one, yes.
So anybody who's not named is not a beneficiary or an heir?
If you're not named in the will, you're usually not going to be a beneficiary. That's correct.
Okay.
Okay.
But if it was a generic kind of thing, like siblings or?
It could say I leave everything to my siblings, and then you have to figure out who they are. Yeah, I have 13 brothers and sisters. There's a lot of that. All right, we're advertising the estate, and that's in 2 papers, which is challenging with the Post-Gazette now not being printed, but the Pittsburgh Legal Journal, and normally a paper of general circulation. So that could be the Post-Gazette, it could be the Courier, the Jewish Chronicle, some other type of paper, but you're supposed to let creditors know that the person passed away.
They're in the legal section, not the obituary.
It's in the legal section. That's correct. It's different than the obituaries. That's right. Okay, this is to give them notice that John Smith has been sworn in as the executor of the estate. Here's the address where you'd be able to make claims, because creditors are supposed to file claims if they have claims against the estate.
So a lot of people look at those to see if they're customers or there.
Do people look at those advertisements for the estates? Yes, they do, because if they're a creditor and they know that we're owed money, they're going to look for that. Yes.
They have a service for that, I guess.
I don't know. I know that when creditors get in touch with us, that they obviously found out somehow, so they want paid. Yeah. So we identify the assets, and that sometimes is, where you want to make sure you have your information organized and together for them. You want to collect your debts. Don't start paying debts until you know you have them all, because you don't know if your estate is solvent or not. Eventually, there's things you have to file with the Register of Wills office, and one of those things is an inventory of assets of the estate. That's due within 9 months of the date of death. And that would list the probate assets, the things in the decedent's name alone, would not include out-of-state real estate, but it would include in-state real estate, okay? You have to file an inheritance tax return. And that is due within 9 months as well. The taxes are due within the 9-month period, but if you make an estimated payment on the taxes within 90 days of someone's date of death, you get a discount on the taxes. So you can save some money by paying it early. It gives the Commonwealth the money sooner. You might have to file federal income taxes. You might have to pay federal estate taxes. But again, you're not paying federal estate taxes unless your estate is in excess of $12,060,000. Okay. Eventually you have to,
However, that number's changing, right?
Yes, that number will change after the first of the year. And I believe it's going up to $12,920,000.
It's going up.
Yes, it's going up.
It's gonna go down.
No, it's the federal estate tax number is going up after the first of the year. Okay, and so are the annual exclusion gifts. This year it's 16,000. Next year it will be 17,000. You close the estate by doing a family settlement agreement or by doing a formal accounting with the court, or there's a way, if it's a small estate, you can do a petition with the court. You distribute the assets to the beneficiaries and eventually close the estate. All right, so here's some more details about these notices, to whom they go, and we've talked about that, so I'm going to move ahead. And you file a certification of notice to let the Register of Wills office know you have notified the beneficiaries. And this is just a copy of the notice forms. Advertising the estate, okay, it runs once a week for 3 weeks. That's giving creditors plenty of time to find out. And creditors have to make their claims within 1 year of the date of the advertisement. So that gives you a statute of limitations. If they don't make their claim in the appropriate time, their claim can be barred.
Does that mean that the estate can't be closed for a year?
Most estates, you want to know how long it takes to close an estate. Usually most estates will take approximately 18 to 24 months. Why? Because you have 9 months to file the inheritance tax return and the inventory. The state, the Pennsylvania Department of Revenue, takes approximately 6 months to review the return. So 9 and 6 is at least 15. Okay, and then you have some paperwork to do to clean it up. Okay. All right, so these are all jobs, things that the executor has to do. Assets, debts, opening an estate checking account. Okay. And there's a copy of an inventory form. And again, these are all online. All right, the inheritance taxes, we've talked about what the rates are. And so again, these are all part of this. It's a big job. So people say, well, I'm appointed as the executor in my mother's will. How fun for me. They sound very excited about it. Then God forbid mother dies and they're like, I didn't realize all this work that I was going to have to do, because it's a lot of work. If you got to clean out the house and you got to do this, you got to deal with your siblings. It's a lot of work. Okay. All right. Okay, paying debts. Now this is really important, because if, as an executor or an administrator, you pay the debts out of order, you can run out of money and be in trouble. So the first thing that gets paid, the highest priority, are administrative expenses. That's the expenses of opening up the estate. That's the executor's fee or the administrator's fee, and their attorney's fees if there's an attorney. The next priority is what's called a family exemption. So if I was living with my mother at the time of her passing and I had provided care and services to her, I'd be entitled to this family exemption of $3,500. It's a recognition by the state that I should be getting something for the services I provided, and it's a deduction for inheritance tax purposes. The next thing are funeral and burial expenses. Okay, so those are nice. Those can usually be a big deduction. Then it's medical expenses or Medicaid. Medicaid is welfare, and that was incurred within 6 months of death. That's the next priority here. Then a grave marker. Now, usually, if you pay for the grave marker, the medical people aren't normally going to come after you, so they kind of let you take care of those things. But technically, it's a lower priority. The rent of the decedent for the 6 months prior to death, if they haven't paid their rent. Claims by the Commonwealth. Now, these could be more Medicaid. If a person was in a nursing home for 2 years prior to their death on Medicaid, the last 6 months before they died would be class 4 all the way up here. But the rest of it wouldn't come until this part here. So other things would get paid. It's just the way you break it down. And then all other debts, including credit cards. Because I have people who always want to rush off and pay credit cards. No, they have the lowest priority. Don't pay it. They can't charge interest or penalties after a person dies. Forget about it. And they're usually the people who don't get their money if you run out of money in the estate. Yes.
So you mentioned you have to set up a checking account for
Yeah.
the estate, and that's how we would do all this administration. But what money, you don't have, like that checking account has no money, so.
Well, no, so you set up a checking account, but you went to the bank and you closed your mom's checking account and you took the money that was in there and you put that in the estate account. That's where the money comes from. Or your mother had at home 50 US savings bonds and you liquidate them and put that money in the estate account because you have to use the money, the assets that she had to pay her bills. When you went to open her safe deposit box, she had $202 bills in there. So that $4,000 goes into her estate account to pay her bills.
So you actually liquidate the other assets.
Yes, you have to liquidate the assets. You sell her house. You get money from the sale of the house, goes into the estate account to pay her bills. Yes. Okay.
We have a question on Zoom. Does rent fall in line with mortgage?
Well, a mortgage, it's okay. So does rent fall in line with the mortgage? Rent for 6 months prior to death, if that's still owed, that has a higher priority. The mortgage payments are going to be paid if you sell the real estate. So if you have to, sometimes the estate will pay the mortgage until the property sells, but it's considered a debt of the estate, and it follows the property. You can't sell the property without paying the mortgage off. Okay, so it's a little more complicated. But so that you sell the house, the mortgage is paid at the closing, and whatever net proceeds you get, that's what would go into the estate account. Okay. All right, and eventually, if you've paid all the bills and you've paid your inheritance taxes and you've gotten clearance from the Department of Revenue, you then can eventually make distribution. And this is where you do this by doing a family settlement agreement. And that's the way most estates are settled. It's something prepared between the executor and the administrator and the beneficiaries, saying to them, we opened the estate, you're entitled to a 1/3 share. There's 3 children, you each get a third. And here's an accounting. Here's the money we took in, here's the money we spent, and here's what's left for distribution. And you're each going to get $10,000. Now, most of the time you want to have that information to the heirs so that they know, why am I getting a check for $10,000 when mom's estate was worth $100,000? Well, you had to pay all these bills. Your mom had the house, but she didn't pay the mortgage. And so the mortgage had to be paid off. And there's a bunch of medical bills and there's these other claims that had to be paid. And it explains to them why they're only getting $10,000 when mom's whole estate was $100,000. Okay, it's important to know. People always want to know, why did I get only this amount of money? Okay. All right, now real estate. Okay, real estate is an asset that people own and they say like, well, it's my house, I'm going to move into mom's house. I don't care about my brother and sister who also have a claim against it. I'm going to move into the house myself. Well, you can't really do that. All right. So you have to be aware that you might have to buy your siblings out, because if that's the principal asset of the estate and you don't want it to be sold, you might have to buy your siblings out. Money goes into the estate to pay the bills, to pay your siblings, and then you could have the property transferred to you. All right. When we do a deed from an estate, it's called a fiduciary deed, not a general warranty deed. If I'm selling my house, I know everything about it. I can warranty what condition it's in. An executor or an administrator doesn't have that responsibility. They're not required to have all that detail about the decedent's house, so they do what's called a fiduciary deed. All right, so sometimes though you have an estate where there are minor children who are heirs, or you have an estate where an incapacitated person is an heir, or you have an insolvent estate and you don't have enough money to pay all the creditors. So you file a formal accounting with the court and it says, here's what went in, here's what went out, and here's left for distribution. And then the court signs off on it. That releases the executor from liability and it settles the matter. It protects the interests of the minors and the incapacitated person. It deals with the creditors. I have $10,000, I owe $100,000. I don't know how to divide this money out from the lowest priority creditors, those credit card people. And you go to court, or you can do an accounting if you have people who don't get along, family members who won't sign off on a family settlement agreement. You got to go to court and get somebody to let you out of this estate. And you should only go to court 1 year after the statute of limitations has passed for the creditor so that somebody can't show up and surprise you. Okay, and that's a form to settle the estate. All right, once everything's been done, you've collected the assets, paid all the bills, you've now distributed the money to the beneficiaries, you can then file a final status report to close the estate out. And the court wants to know that if an estate stays open for a long time, let's say I have a piece of real estate in a place, I can't sell it. Nobody wants to buy it. All right, it's in, I don't know where it is, but it's somewhere I can't sell it. And so I might have an estate that would be open for a number of years because it takes that long to get, perhaps now a flipper might buy it, but I couldn't sell it. I've been trying and trying, and so the estate may go on. You have to file status reports periodically to let the court know what's happening with the estate, because they want to know. And again, this is a statewide form that you can find online. And, okay, and now we've administered our estate. The executor has taken a fee for all the hard work that they did, okay? They've paid everything and everything's done and they can sit back and relax.